but you don't get to keep doing it and then get rewarded for continued bad behavior, right? You don't go to prison for something typically and then get a better deal the next time you do the same thing. You see how that doesn't make sense to me and to most people?
In Your Honor, brief argument, we are asking the court to follow the agreement. Mr. Diggs does have a lifestyle and a plan, work and paying child support, a life now that does not seem like anything that the court is reviewing now. The court does have the mechanism, of course, to really put them in jail for a long time. The moral recognition therapy could work. Any other type programs that court may have. We believe he can do it.
I mean, and so I guess the case is from 2024. Have you been out since then on bond? And I got the letter, and I'll take judicial notice to the court's file. It does include a letter that was sent over by your attorney from Mr. Peterson, who I used to work with and trust and value his opinion greatly. And he sent a very supportive letter about you working in that office building and that everyone valued you there. So obviously, maybe you finally figured it out because the criminal history doesn't look like it, but you're older now. A lot of this was when you were younger, but you got to realize that it doesn't matter if you get scared. It doesn't matter what you're doing. If a cop says they want to talk to you for any reason, you would have been talked to them and not been here in felony court if you hadn't ran, you know? So being scared isn't an excuse anymore, because if something happens, if I go follow this probation, and something happens while you're on this probation, you're looking at the 10-year sentence that you've already agreed to. No negotiations, 10 years in prison. Do you understand? All right, then I'm going to find that you entered your previous plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Also find the prior offenses, convictions true that you pled true to. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. The order to pay the
6 years, Judge. It's 10 probated for 6.
Okay, sorry, the PSI has it as 10.
That's right.
So that would have been one of those corrections.
Yes. I
That's
apologize,
for-
Ron.
6 years probation. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. It sounds like this shouldn't be a problem for you. It's just following the rules, going to probation, do your community service, keep working, and you should be fine. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and your probation can be revoked and you would be facing that 10-year sentence that you've agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you.
Would you turn that video down and see if maybe it'll kick on?
Terrence Harrington is around. He was earlier on the
Okay,
docket.
thank you. I know, I just feel like it's getting stickier and fire. Let's see, okay. I'm kidding there. I already called it and he asked me to wait. Deanna Paul, Mr. Samuel.
Perhaps so. You know, I just basically what the prosecutor.
Hold on, let's get everybody.
Okay.
Thanks. I said thanks.
Oh.
Good morning. Good morning. Are you Deanna Paul?
Yes, ma'am.
And this is 25 DCCR 1792. Ms. Paul's charged with stalking, and what is the announcement?
Your Honor, I've spoken with the prosecutor. We reached an agreement. We'd like to reset and come back, take care of that.
So it will be up for a plea. I can put it on the plea docket.
Yes,
So, Ms. Paul, I'm going to reset your case to the plea docket, and we'll get your plea taken care of on that next court date. Stay in touch with Mr. Samuel. He'll let you know when you need to be back. Thank you. Free to go. Thank you. And is Mr. Rojas, you've got Terrence Purrington. I understand he's,
Okay, Jay, we're down the hall, just.
all right. I'll recall that bond forfeiture. All right, sir. You're Terrence Purrington?
Good.
And so, Mr. Purrington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right, Mr. Purrington was previously in court and cause number 25 DCCR 1114, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
we have your own.
Any additions or corrections?
Not from defense.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it?
Really?
It is. That's how they give it to you in little plastic baggies.
No, that's, you see.
She's asking for stuff.
I'm asking you.
Is that?
What, here's the thing. I'm sorry.
He's in the bag. Plastic bag.
Is that how they give it to you?
No,
Okay.
you just, I put it in there
Why would you do that?
for the smell.
For the smell?
This
To block the smell?
right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. Smell like.
Well, how about don't keep it in your car at all?
That too.
That too.
It's-
So here's the thing, having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of your probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification. It shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork. Mr. Burbank, you've got Rakeem Allen, 3 cases. Good morning. Are you Rakeem Allen? Speak up, please.
Yes, ma'am.
And this is cause numbers 25 DCCR 1163, 1164, and 1697. Mr. Allen is charged with evading arrest or detention with the use of a vehicle and 2 cases of possession of a controlled substance. Mr. Burbank, what is the announcement?
Your Honor, I've been talking to Miss Chase about this. Mr. Allen and I had a communication problem in the last couple of weeks. It looks like we have corrected it. It had nothing to do with witnesses, but actually getting in contact. I would ask for one more reset, Judge, to see if we can't, the office 10 years or 12-year cap. And I was talking to Miss Mofino about another option.
Mr. Allen, do you have the drug patch? I don't see the most recent results, and so I'm gonna have you have a seat in the jury box and let's get a test this morning, just because I don't have the most recent results. The last one I have was positive.
Well,
That's fine.
We've got probably 10 positives on him ever since he first got these cases. He keeps finding out. So I was gonna ask you to test it. Thank you.
Oh, she must be in the lab.
Oh, yeah,
Right.
I remember this. That's unfortunate. Okay. Tiana Hughes, Mr. Burbank.
Yeah, this year's.
Good morning, ma'am. Are you Tiana Hughes? And this is 25 DCCR 1058. Ms. Hughes is charged with credit or debit card abuse. And Mr. Burbank, what is the
I
announcement?
hate to tell you, just one, a reset, this would be dispositive, needs to get her money together. She had, had some problems with the bank and some other stuff, reference straightened out. But she has, corrected that. So if I just get a normal reset, it should be finished next time.
Okay, so any issues?
No, Your Honor.
All right, we'll just do a normal reset, Ms. Hughes. Make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back for that next court date. Okay, you're free to go. Cody Litchfield. Good morning, you're Cody Litchfield. And this is cause number 26 DCCR 0646. Mr. Litchfield is charged with attempt to commit arson. And Mr. Burbank, what is the announcement?
I am not finished with discovery. I'm trying to get some video of this, through the fire department in the county. And so that's where I'm.
Any issues, Mr. Nichols?
No, Your Honor.
All right, we'll just do a normal reset. Mr. Litchfield, stay in touch with Mr. Burbank. He'll let you know when you need to be back.
You're free to go.
You're free to go. And Crystal Robertson. And then don't leave after you're done when I've mentioned something. This is Mr. Coleman's case on a Crystal Robertson. Good morning, ma'am. You're Crystal Robertson.
Yes, ma'am.
And this is 25 DCCR 1526. Ms. Robertson is charged with forgery of a governmental instrument. And what is the announcement?
Your Honor, she is in between jobs. What I mean by that is she has a job, she's just gotten a better job, and there is a bonus. She's going to a government entity. This is a case of restitution and then solution for final disposition. So I would ask Judge, and that was the intent of the prosecutor and myself, so that we can get this by her so that she doesn't have any felony.
When do you anticipate?
July.
Okay, so we'll just do a normal reset.
Yeah, sure.
And so, Ms. Robertson, I'm going to reset your case normal about 30 days or so. Stay in touch with Mr. Burbank. He'll let you know when you need to be back. Right.
Okay. I think that's all.
All right, if I call your name, please come forward. Marilyn Close. If you'll call that name, please.
Maryland. First question.
All right, she did call and mention that she was in Florida. I'm going to forfeit her bond though for non-appearance, reset it at 100,000. And then if the bondsman gets us proof of that, then we'll recall that forfeiture.
Yeah.
Terriana Frazier. Good morning, ma'am. Are you Terriana Frazier?
Yes, ma'am.
And Ms. Frazier, were you able to get someone hired?
Not yet, but I spoke to four of them, and I was trying to see if it's too late to get a court appointed lawyer.
Well, no, it's not. Who'd you talk to?
Thomas Burbanks.
Speak up, please.
Thomas Burbanks, Thomas Holmes, Mark Cameron, and James Patterson.
Okay. And are you working?
Oh, yes, I do have.
You do what?
I do have.
Okay, so what I'm gonna thank you for doing what I asked you to do. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it, okay?
Yes, ma'am.
Step in front of the clerk on the end. Jonte Harmon.
Yes, ma'am. Don't leave and just. Thank you.
Good morning. Are you Jonte Harmon? And this is your initial appearance. Ms. Harmon, in cause number 26, DCCR 0765, you're charged with the second-degree felony offense of burglary of a habitation. And that is from February 6th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so are you working? Okay, so what I'm going to do, Ms. Harmon, is reset your case for about 30 days or so to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get here to that attorney and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. You understand?
Yes, ma'am.
All right, if you step in front of the clerk, she'll give you a reset notice. Good morning, sir. You're Nathan Hester.
Ma'am.
And Mr. Hester, did you get a lawyer hired?
Not yet. We get some money together to get one. It's gonna be right.
You're going to hire Rife. When do you think you'll be able to get Mr. Kimler hired?
A couple of weeks.
Okay. And you've already talked with him and know how much you need? Okay, so I'm going to give you one more reset. You need to get him hired before that next court date, okay? Step in front of the clerk. Good morning. Are you Marvin Davis? And Mr. Davis, this is your initial appearance and cause number 26 DCCR 0754. You're charged with the state jail felony offense of injury to a child from February 11th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I talked with 4 lawyers
Okay,
and I talked to Tom Kelly, Brittany Holmes, Sonny Eckhart, and Jason Bailey.
okay.
We have a job and I have check stubs here. I'm gonna provide like,
Right.
but I don't really, I do either. I don't really make enough to be able to afford them.
Okay. So what I'm going to do is have you fill out some paperwork this morning, Mr. Davis, to see if you qualify for a court-appointed lawyer. Make sure you fill that paperwork out accurately and completely, and you're going to swear to oath that it's all true and correct, and then I'll take a look at it, okay?
Also, I have a few questions on my bond condition.
Say it again.
On my bond condition, I know it won't happen now, but I had a question about seeing if I can get like women in bond condition
Of what?
of like not interfering with the victim or well the victim that is on this case is in CPS.
Okay, so for now, the bond, you need to, that's one of the reasons you need to get an attorney, talk to them, make sure whatever that bond condition is, where you don't have contact or communication, keep doing that until you get a different order from me, okay?
Yes, and
All
I
right.
have my caseworker here as an advocate to
Okay,
advocate for me for that.
perfect. And just because I don't know anything about it other than what the allegation is, we'll leave the bond conditions in place again until, we talk more about it and you have an attorney.
Yes.
So step in front of the clerk on the end and she'll give you that paperwork to fill out. Can Derek Simeon? Good morning. Are you Kenderick Simeon?
Yes, ma'am.
And Mr. Simeon, this is your initial appearance
Yes.
in cause number 26 DCCR 0457. You're charged with the second-degree felony offense of assault on a peace officer, and that's from February 20th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'll do, Mr. Simeon, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me back the names of the lawyers that you talked to, so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you a reset notice. Good morning. You're Michaela Sylvester?
Yes.
And Ms. Sylvester, this is your initial appearance in cause number 26 DCCR 0766. You're charged with the second-degree felony offense of burglary of a habitation from February 6th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so I'm going to do, Ms. Sylvester's reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order. You would go back to jail. Do you understand?
Yes.
So you and Jonte are co-defendants, right? All right. I just printed something. Y'all both hang on just a second. I want to take a look at something, and then I'm gonna give y'all some rules. Did y'all come here today together?
Yes.
Ms. Harmon, come back up.
Yeah.
Do y'all live together?
Yes.
Where do y'all live?
Well, we was at Autumn Oak, but they moved out of there like a couple of days ago. So we're going to be at this hotel on College Street 3 minutes.
How old are y'all? How old are you?
18.
18?
18.
So first thing, condition of both of your bonds, if it's not already a condition, is that you guys aren't to be anywhere near the Autumn Oaks apartment. Y'all cannot go anywhere around there. Do you understand?
Yeah.
You also cannot have any contact or communication with Kraisha Young or Tyrone Harmon, who I know is your brother,
My dad.
your dad. And who's Kraisha Young?
My stepsister.
Your stepsister. And they're the one, they live over there at Autumn Oaks.
Yes, ma'am.
So y'all need to stay away from both of them for now.
Okay.
Don't talk to them. Don't have anything to do with them. Don't have communication with your dad right now or anything like that. Do you understand?
Yes, ma'am.
Okay. Usually I order that you, if there's co-defendants, that y'all not have any contact or communication. Do y'all have anybody else to help y'all financially do anything? Okay. So I'm not going to order that, but obviously y'all need to stay away from that situation. If anything else comes up while you're out on bond, where you two aren't getting along and there's some other issue and the cops are called out or you're kicked out of a hotel, then I'm going to order that y'all can have no contact or communication with each other. Do you understand that as well?
Yes, ma'am.
Okay, so whatever's going on, y'all are in felony court now. Y'all are young. You need to grow up, make good decisions, so that you can get your cases taken care of and not be back here in trouble and or in custody.
Yeah.
Okay, all right. Did you get your reset notice? Step over here and get your reset notice, then y'all can leave.
Yeah, and then you got to.
You can go. Bryson Griseski. Good morning, you're Bryson Griseski.
Yes, ma'am.
And good, Mr. Griseski, did you get someone hired?
Yes, ma'am. It's just been a payment problem. I'm hiring Rafe Gilmer. He's a family friend of my sister's.
Okay,
So I'm hiring him, but it's a financial thing. I'm self-employed. I have a carpet cleaning van. And so in a few weeks, I'm gonna hire him if that's okay with you.
so I'll give you one more reset. That's about 30 days. To get him hired. If something's going on and you're not busy enough, you might need to try to find extra work.
Yeah, I got some stuff coming up.
Okay, perfect.
ma'am.
So we'll reset you to hire Mr. Kimler. If you'll step in front of the clerk, get that reset notice, make sure you bring it to his office
Yep.
when you get him paid.
Thank you very much.
Michael Pelican.
Thank you so much.
Good morning. Are you Michael Pelican?
Yes.
And Mr. Pelican, this is your initial appearance and cause number 23-41539. You're charged with a third-degree felony offense of unlawful possession of a firearm by a felon. And that's from September 9th of 2022. And since you've made bond in that case, have you had an opportunity to try to hire a lawyer?
Oh, ma'am, I had talked with Mr. Charles. That was my initial attorney.
Mr. Rojas?
Yes, ma'am. But he said he couldn't be my attorney no more because she dropped.
Well, what happens is he's actually still your attorney, but once you make bond, I expect you to try to hire your own. You can hire him, you can hire anyone else. And so what I'm going to do is reset your case about 30 days to give you some time to try to hire someone. If you get a lawyer hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order. You would go back to jail. Do you understand? All right, step in front of the clerk to give you your reset notice. Tamika Reed. Good morning. Are you Tamika Reed?
Yes, ma'am.
And Ms. Reed, this is your initial appearance and cause number 26 DCCR 0786. You're charged with the state jail felony offense of criminal mischief from February 10th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, they gave me a court appointed lawyer.
Right.
Going to arraignment, Mr. Charles.
Yes. So when you're in custody, you automatically get a court appointed lawyer. So now that you've bonded out, I expect you to try to hire your own lawyer.
I can't afford one. Like I said, I get Social Security, but they stopped my disability.
Why'd they stop it?
I'm on appeal right now. So you know what's going on with me.
Okay. So it sounds like you need to try to get a job then, huh?
Well, I can't work.
Why?
I'm disabled.
Well, if the Social Security Department does not say you're disabled, then there's probably something out there that you can do, right? And so what I'm going to do is reset your case about 30 days to give you some time to do a few things. One, I want you to bring any documentation you have of the Social Security, what's going on with them, appellate papers, whatever you have, bring that in. I also want you to try to find some kind of job and bring me some proof that you're trying to find that. All right. You need to look at least 5 places a week. All right. Step in front of the clerk. She'll give you a reset notice. Run, go back outside. The tax. Mr. Parker on Christopher Hunt. That's what this Malfino.
No.
Right, sir.
It's an initial.
Oh, y'all might not even have.
Here, I've got the information from Ashley, so you'll know.
if you want.
Be nice to know. All right.
Okay.
You can keep it till you know her.
All right, sir, are you Christopher Hunt?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Mr. Hunt, in cause number 25 DCCR 1766, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. So is it assault family violence?
No, it's just Class A assault, not family violence.
Okay. And that's from September 28th of 2025. And how do you plead to that charge?
Not guilty?
No.
No, guilty?
Here's the,
Did you do it or not?
yeah, it's okay. So are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Do you understand? I'm assuming one of those would also be that you have no contact or communication at all with David LeBlanc. Do you understand? That's obviously in person, but that also means any type of communication. You can't send messages or through social media or anything.
Okay.
That'll be a part of your probation. You understand?
Yeah, well.
Yes.
Okay.
What? All right. So, are you a US citizen?
Yes,
So what's the relationship with Mr. LeBlanc?
that he was a friend of my mom's.
Okay.
He was staying at my house.
All right. So obviously that's no longer acceptable. You cannot be around him at all, period.
We'll make sure that happens.
Okay. State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Hunt is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and follow all of those rules, at the end of your probation period, the case will actually be dismissed if you're successful. So you won't have the conviction on your record.
Oh,
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You would be found guilty of the offense and you could be sent to the Jefferson County Jail for up to 1 year. Do you understand?
yes, ma'am.
All right, if you'll just have a seat here in the courtroom, probation sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. Just wait for her to call you up.
We thought you were gonna call the next one.
Oh, I gotta get to that docket. I'll get there in just a second. Don't make me think I'd already said something.
You did, you don't remember?
I don't remember. That could be a problem. See, Stephen Gray, Mr. Parker. Now I'm there.
Yes, ma'am.
Good morning. Are you Stephen Gray?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Gray, in cause number 26 DCCR 0294, you're charged with the 3rd-degree felony offense of driving while intoxicated, 3rd or more, from December 27th of 2025. The indictment alleges you were previously convicted of driving while intoxicated June 27th of 2012. And after that was final, you were convicted of driving while intoxicated March 7th of 2014. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
And are those 2 prior convictions true?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. Y'all mark.
$1,000 fine.
Okay,
Sorry, and I didn't put 10 days.
that's a condition, that's required. So it looks like the fine would be $1,000. You understand the condition of getting probation is also that you would have to serve 10 days in jail
Yes, Your Honor.
and follow all of the other rules and conditions of probation.
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number one.
Objection.
It's admitted. Is there any evidence that Mr. Gray is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. But what I'm going to do is reset your case for about 30, well, actually, it's to be a little longer than that, so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today. She's sitting at that desk right over there. All right, we'll see you back at sentencing. Junius Vital.
Your Honor, that's Ms. French's case and it's an unagreed plea. I don't know if you want to wait on her.
Okay, is she coming?
Okay.
Okay. Good morning. Are you Junius Vital? And this is 25 DCCR 1374. Mr. Vital previously was here, entered a plea of guilty to the third-degree felony offense of failure to comply with sex offender registration requirements. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Judge.
Any additions or corrections?
None of them were, Judge.
Nothing to
All right, Mr. Parker, you may proceed.
Your Honor, Mr. Vital, he's, as far as I understand, he's done a pretty good job reporting for the last 10 years. He's lived around here and he's also lived in the Houston area. I think the Houston was the last place that he was registered properly. He ended up going to a place called the Wheelhouse. I know it's called the Wheelhouse.
Yes,
in Deer Park area. He tried to register there, but he wasn't actually a resident. He was doing jobs out of there, but he was living in his car. And then when they denied him because of city ordinance, that's why he couldn't live there, city ordinance rules, then he appealed it and it still got denied. And then he applied. He was going back and forth between his sister's house in Beaumont and working there in Houston. And you tried to apply here in Beaumont as well on.
That's where I registered at Beaumont.
So
And
where are you registered right now?
My sisters on Kipling folks in Beaumont.
In Beaumont.
Yes, ma'am.
And that's where you're living and you are properly registered at this
Yes,
time.
ma'am.
and I believe he's had some issues in the past. He had a substance abuse issue. He's done well with that. I think, he's not one that just ignored what he's supposed to do. I think he's tried, which is way more than I can say for a lot of people. And we're asking the court to give him probation, Judge.
Mr. Smith?
Judge, the state's going to argue for 4 years in prison in this case. The nature of the previous aggravated sexual assault of a child, I think the facts were fairly aggravating, and he was given probation initially, wound up getting revoked when he committed a new offense, and was revoked and sent to TDC for a 30-year sentence and then a 20-year sentence. It looks like even the PSI notes that even though the criminal history is limited, the circumstances of the offenses are severe. He was given probation in the past that resulted in revocation, and looks like he does try to justify his actions in the PSI interview.
I may respond.
Hold on, I just want to know, when did you parole out? How long have you been out?
2015.
2015? And so since 2015, there haven't been any issues with reporting or And it looks like, so while you were on, since you've been on parole, you've also gone to ISF, correct?
Yes, ma'am.
Okay,
That's why I was still in parole. I discharged in 2022.
you did?
And I would just like to say that, you know, part of his revocation was, as according to him, and I think the probation officer, was substance issues, and I think that's part of the reason why he didn't.
Well, yeah, I mean, it was revoked a year after based
Right.
on a possession case. And that, I mean, I don't disagree with Mr. Smith, but the criminal history, I mean, we're talking about 1991, 1993. We've had 11 years of reporting, and the wheelhouse is somewhere. I understand you're trying to get some help and do some good things, but you understand you can't do that if you can't.
Yes, ma'am.
You have to be able to be somewhere where we know where you are.
Yes, ma'am.
And that you're properly registered.
And that's when they went and denied me out there.
Go ahead.
When they denied me out there, you know what I'm saying, I talked to them. And when I came, I said, I'm just going out there and going, you know, register, you know, back in Beaumont. And then I was still trying to, you know, continue, you know, so working the program.
Right.
Drug and treatment program.
So are you clean now?
Yes, ma'am.
Just double check that this morning, okay? Have a seat in the jury box. I'm gonna have you drug tested this morning. Mr. Parker, you've got Regina Williams, 2 cases.
But yeah, Jared,
I'm sorry.
I haven't done any paperwork on it, but. This is Ms. Malfino's case. We're supposed to be providing Ms. Malfino with an affidavit. We have a copy of the affidavit, but it hasn't been signed. I told her that the person needs to actually go to the DA's office to present it to him. So that's where we are. I mean, she showed the document to me today, and I'm trying to get her to get the victim to go, or not the victim, this person to go to the DA's office and sign the document in front of them. And that should resolve the case, but I can't.
Both cases?
Both.
So I mean, this is gonna be the last reset. So either they go up there and do what they've got to do. They've got to go to the district attorney's office to do that. You can't just take something for them. They have to go do it. Okay? And if they don't, then when we come back, we'll have to work something else out. All right?
And don't-
This will be the last one.
Don't wait till day before court because, okay, well, I'm just telling you.
Talk to them and tell them if they don't go take care of this soon, then it's gonna be you having some issues here in court next time, okay? All right, you're free to go.
Thank you, Judge.
Thank you, sir. Mr. Rojas, you got Terrence Currington's the sentencing? Terrence Currington?
Yes.
Bond will be forfeited for non-appearance and reset at 100,000. If you can get in touch with them and get them here because it's an agreed probation, so I'll consider recalling that forfeiture if he shows up.
Thank you.
Yeah, she's.
Mr. Lewis, you've got Devontre Johnson.
Yes.
Devontre Johnson. Good morning. Are you Devontre Johnson?
Yes.
And this is 25 DCCR 048. Mr. Johnson is charged with failure to comply with sex offender registration requirement. And what is the announcement?
Judge, notes on Ms. French's file show that there is a new fair to register case that's in intake right now. So she has withdrawn the 5-year cap offer that she made.
Okay,
So we request a reset.
so that
for
one
the new
should,
case again.
okay, but it's already there and it can get taken care of before that next court date, I'm sure. You'll make sure they know. So what I'll do is I'm going to reset your case about 30 days. It sounds like there is a new charge that could be indicted between now and then. Stay in touch with Mr. Lewis. so that he can then get the information on that one, get a new offer from Ms. French, and we'll see where we are at the next court date. All right, you're free to go. Mr. Paget, you have Catherine Bautista.
I thought paperwork, Your Honor.
Just a paper set.
Okay, I'll call it in just a second.
You don't mind.
Mr. Samuel and Deanna Paul,
I just had her wait outside and visit with prosecutors.
I'll hold it.
Thank you. Yes.
So do I need,
Okay.
to call this one? What is the, it says, there's that from.
To let you know, and at this time, that's, I came, right, just to let you know, it's how it has.
This time. Like make, and then check mine too. Right, check my phone. Okay, gotcha. Oh, no, that's fine. Marvin David?
Sorry. Sorry, I know you're waiting on PGA and Mr. Allen.
Yes. Mr. Burbrick, don't leave, don't forget, we're waiting on that, UA on Mr. Allen. You can go wherever as long as you come back.
He should be out.
Is that even federal court?
Oh, did they?
Yes, he's.
Oh, okay. It'll be, sounds like they're done. We're just waiting on the paperwork.
You see by his own.
That's what I saw. Mhm. Yeah. Mr. Parker? Mr. Vitale? All right, we're back on the record in clause number 25 DCCR 1374. Mr. Vitale tested positive for cocaine. So, Mr. Vitale, you've been to ISF twice while you're on parole. So parole's given you two opportunities not to revoke your parole. And you get off parole and here you are with another felony and you're using cocaine again.
You need some help, Miss Ma'am.
I'm sorry?
I just need help.
Well, you've gotten the help and you're looking at a cap of 4 and I was well on my way to giving you an opportunity. But there's no way I can do that with your criminal history and the fact that you've been given, because if you hadn't been to ISF, I'd say, okay, maybe I'll send you to ISF, but you've been twice in the last 5 years. All right, at this time, I'm going to find that you entered your plea of guilty previously, freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements, sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Mr. Paget on Catherine Bautista.
Yes.
Hmm.
Good morning.
Good morning. How are you?
You know, the gentleman that was up there that works in Tommy's office.
Uh-huh.
I could have testified.
Said the same thing.
You guys that
does what he says there.
Well, that's what,
I've never moved from the office
What-
I was when you first. got
okay.
there. So,
Good morning, you're Catherine Bautista. And, will your client waive the formal reading of the indictment?
she will, Your Honor.
Ms. Bautista, in cause number 25 DCCR 1608, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from September 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 3 years. You would be ordered to pay a $300 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections to stage 1, Your Honor.
It's admitted. Is there any evidence that Ms. Batista is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty.
There's one, she had a case 10 years ago that ended as a state jail revocation, but that's it, Judge. I don't see any reason.
Not to waive?
Not to waive.
All right, so Ms. Batista, I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty, and at this time, find you guilty of publishing or threatening to publish intimate visual material. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated. You'll be on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you'll be able to serve that 2-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 2-year sentence that you've agreed to. Do you understand?
Yes, ma'am.
And I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. It's printing, I think. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Paget.
Yes, ma'am.
So if you'll just have a seat here in the courtroom, probation is sitting at that desk right behind you. She's going to call you up to her desk when she's ready to go over your paperwork. So watch for her to call your name.
Okay.
All right. And if you'll make sure and send that attachment over.
Diane, it's like asked her to, but it was fine. But judge.
Okay, yeah.
whether or not to-
We, the
Yeah.
situation was we.
I only did it because he was having trouble accessing it.
Okay.
We talked prior to court.
Okay. All right.
She's saying.
And that's why I couldn't see it this moment. I tried to print it. I-
Maybe-
Blank for
It
you
was
too.
blank.
Maybe go ahead and write it out.
Yeah, if you'll just get a sheet of paper and write it out.
Sure.
Mr. Burbank, that's his, how he takes care of his.
I-
But if you'll write it out real quick.
Yeah, I don't have a problem. with it.
Yeah, just because we can't close it out since I sentenced her today. And so if you'll do that before you leave, that'd be great. Thank you.
I'll get some paper in there.
I tried on. Here's what it is. Don't get that. You won't do that.
Your Honor, first.
Yeah. Let's see, Rakeem Allen. All right, yes. All right, Mr. Allen tested negative. So obviously that's good. You need to continue to test negative. If there's a positive drug screen that comes back, those bonds are going to be high enough to where you can't make them. All right, so we've gone through this too much, but I don't have any, but it looks like you've finally gotten the message that you can't use while you're out on bond. So we need to reset then.
Yeah, sure.
Just a normal reset. All right, stay in touch with Mr. Burbank, talk to him well before that next court date so that we'll be prepared on the next court dates for you guys to make an announcement, okay? All right, free to go.
Excuse you.
Yes, thank you. Mr. Gertz, you've got Miguel Martinez. And this is Ms. French.
The courtroom is entering one of the most serious moments of the day. The charge on the table carries life-changing consequences, and both sides know that every decision from this point forward matters. Notice how the defense isn't asking for a trial, they're asking for time. That usually signals that major plea negotiations are happening behind the scenes. Sometimes the biggest courtroom battles don't happen in front of the judge. They happen during negotiations outside the courtroom. What would you do if you were facing a decision that could affect the rest of your life? Let me know your thoughts in the comments.
Good morning. Are you Miguel Martinez? And this is 25 DCCR 0584. Mr. Martinez is charged with aggravated sexual assault of a child. This was the last reset. So what is the announcement?
Judge, as you know, I've been in trial the last several weeks. I got an offer toward the end of last week from Ms. French. It's a pretty daunting offer. We are not intending on going to trial. What we're asking is 2 weeks to allow him to get his sort of affairs in order, to explain what may be the parameters to his family, all of those things. But we're not going to come in and announce trial after that.
Okay, so
it's going to be some kind of resolution. I just don't know if we're going to accept this deal or potentially plead open to the court.
But it'll be a plea in 2 weeks.
I anticipate it will, Judge.
All right, we'll reset it for a plea in 2 weeks. Mr. Martinez, make sure you stay in touch with Mr. Gertz, and then we'll get it taken care of at the next court date. Mr. Gilthorpe, did I sleep? On Marco Morales. Uh-huh.
Right, Mr. Church is here. There's some confusion about it being, this case from 2 weeks ago being reset about bond hearing. We already had the
I don't have it on the docket.
okay. We already had the conversation with him about, okay.
Yeah, I wouldn't think that.
Shut up, sir.
Yeah, that.
Shut up.
Good morning. Are you Marco Morales? And this is 26 DCCR 0160. Mr. Morales is charged with evading arrest or detention with the use of a vehicle. Mr. Gilthorpe, what is the announcement?
If I could have one reset to negotiate with Ms. Mulfino, she has already extended an offer. But she and I had a discussion. We were just seeing if something else would work.
Okay, so
I anticipate a plea.
I'll reset one more time to give you some time to get that taken care of. Mr. Morales, make sure you stay in touch with Mr. Gilthorpe so that you know what's going on, and we'll get an announcement at the next court date. Okay, you're free to go. Yes, sir. Ms. Holmes, you've got Kristen Bell.
Better. Yep. It's worked out. Thank you.
Okay, good. Thank you. You too. Good morning. Good morning. Kristen Bell is Miss Mulfy. I'm sorry, it's Miss French's case. Good morning, ma'am. Are you Kristen Bell?
Yes.
And this is cause number 25 DCCR 1812. Ms. Bell's charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, this is our first setting. I originally had received a no offer from Ms. French that she wanted to get more information on CPS records. And then she sent me a revised offer Friday.
Okay.
I haven't had a chance to move forward with Ms. Bell.
All right, so we'll just do any issues that you see, Mr. Smith. We'll just do a normal reset. Ms. Bell, make sure you make an appointment, go visit with Ms. Holmes before that next court date so that you can be prepared for an announcement at that time. All right, you're free to go.
Thank you.
Yeah, Ms. Warner on the end, she'll give you a word. Kenneth Cormier. This is Mr. Coleman's case on Kenneth Cormier. Good morning. Are you Kenneth Cormier? And this is 25 DCCR 1113. Mr. Cormier is charged with obstruction or retaliation. What is the announcement?
Your Honor, I know this case is getting a little old.
It's getting way old.
Yes, ma'am. If we could get one more, we're close. There was some mitigating factors I wanted to give as far as employment and everything for Mr. Cormier.
Here's what we're going to do. I'm going to reset it 2 weeks. So whatever needs to take place in
Yes,
those
ma'am.
2 weeks. This will be the final reset. Mr. Cormier, if there's any information that you have that Ms. Holmes needs, you need to get it to her quickly so she can get it to Mr. Coleman so that we will get an announcement one way or the other the next 4 days.
Yes, ma'am.
All right, thank you.
Okay.
You're free to go, sir. Courtney Jones, signing a dismissal in that case right now. She's free to go.
Okay. You.
Thank you. Looks like that's all you got.
Yes, ma'am.
And then. Logan Eaglin, I'm signing a dismissal. That's not on today's docket, is it? Okay. Got it.
Okay.
We haven't seen Mr. Jeffries yet. Oh, okay.
Okay. Thank you.
What about Mr. We've seen Brian.
No. Okay.
Mr. Mitchell, you have Kevin Boyd.
Yes, we just worked out. Play agreement on.
I'll hold it.
I'll get the paperwork address.
Thank you. And then what about Henry Littlefield? This pulled out. All right, so Mr. Boyd, in clause number 26, DCCR 0227, the state has elected to proceed on a lesser included offense of a driving while intoxicated second. And that's from November 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And then the indictment further alleges that you were previously convicted of driving while intoxicated February 9th of 1984. And is that true or not true?
Yeah.
True or not true?
True.
And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Mitchell? The papers on the tablet, did you go over those with Mr. Mitchell?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, you.
And it looks like the agreement that you've reached is for a 1-year term in the county jail, but that would be probated. You'd be on probation for 2 years. You would be required to have the ignition interlock device for that entire probation period.
Yes.
As well as paying a $4,000 fine. And in addition to that, there is no waiver of the state DWI super fine. That's something with you and the state. Do you understand?
Yes.
And then Judge, just for your,
State would request that certified.
All right, thank you.
and right now he has the handheld blower. He does not have a vehicle that he's driving. So he does have that.
Okay, so if you're not driving,
Yes.
you cannot drive any vehicle unless it has that auto ignition interlock device.
Yes.
If you're not driving, then part of your probation would be to keep that handheld the entire time as
Yes,
well.
ma'am.
All right. And you're a US citizen, correct?
Yes.
State tenders number 1.
No, Judge.
It's admitted. Any evidence that Mr. Boyd is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, driving while intoxicated second. Sentence you in accordance with your agreement to a term of a year in the Jefferson County Jail, but probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine and to so with the DWI second, it's 3 days. So there's a requirement of 3 days in the Jefferson County Jail by law. Are you working? So what I'm going to do then, Mr. Boyd, is order that you serve those 3 days starting this weekend. So you will report to the Jefferson County Jail Friday at 6 p.m. You're going to serve 3 days. So you'll get out on Monday. That way you get it all taken care of at one time. It's very important that you are on time, be at our jail at 6 o'clock, no later. Also, it's obviously very important that you show up not intoxicated or anything like that. Some people think it's a great idea to show up and, sleep it off. Don't do that. If you're late, if you don't show up, that's a violation of your probation and you'll be right back in court. Do you understand?
Yes.
Also, I'm ordering that, again, the state's super fee is not waived. The state has requested that, and so it will not be waived. I'm going to hand you second the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal.
Yeah.
It's coming. Anything else I need to, I think I said it all. Yeah, make sure you go, if you don't have the attachment. And Mr. Mitchell, you can either email today the attachment, or if you want to handwrite it on something, what you looked at, you can do that as well. But we need it today before we close out the case.
That's fine. I can call Mackenzie real quick and have her send it over.
Perfect. If they'll email it to Ms. Holmes, that'd be great. All right, here's that trial court certification. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork, and she's sitting right behind you. So watch for her to call you up, okay? And again, make sure 6 o'clock this Friday, which is the 20. What's the Friday?
Does he need anything to get in, Judge?
I don't think so.
Okay.
It'll be there.
Okay.
All right. Thank you.
Judge, I'm gonna take him out in the hallway for just a second, and I'll go right back. Yeah.
Okay, thanks. Are you Michaela Collier?
Yes, ma'am.
So this is 24 DCCR 0751, Mr. Kimler, I don't see that you have filed anything that I requested get filed before today.
I didn't understand why I have to file a writ. I mean, it was an illegal sentence. I mean, she never should have received the sentence. They couldn't, the court have the power to vacate the sentence.
No, I don't without a motion.
I did, I filed a motion to vacate the sentence, yes.
I don't see it.
That's how it's come, or question.
It's not.
I think there was a motion.
It's not a quash. That's not,
There
and
was-
that's why I sent you, and I talked to Mr. Florence, and you said that you were going to talk to Mr. Florence. And we did all the research, and I've done all the work for you, which is very frustrating.
All the work, I filed the writ.
Before today. And I mean, literally 3 days after court, I handed you on a silver platter, here's what you need to file. You emailed back that you would talk to Mr. Florence if you had any questions and get it filed. So today, what can happen is if you would like to make an oral motion for me to vacate all of the proceedings, I would entertain that oral motion.
Yes, and I think I filed a written motion to vacate along with the beginning of the case.
To vacate or to quash?
But maybe, I thought of it, it should be to vacate. I don't know, maybe to quash the NTRP. I don't know.
It's a motion to quash. Would you like to file an oral motion to vacate all of the proceedings?
Yes, Your Honor. I'll move it this time to vacate the prior proceedings in this case based upon the fact that it was not a knowing voluntary plea, since she was pled to what she believed to be straight probation, which was an impossible or illegal plea. And that her decision to enter that plea was therefore based on I would say ineffective advice or ineffective information. So it's a
So-
voluntary plea.
So what I can do at this time is grant that oral motion to vacate as a writ under 11072. And so I'm going to grant that motion as treat it as a writ of habeas corpus under 11.072. I'm going to vacate all of the prior proceedings. And so we are now starting at step number 1. And so I'm going to reset the case for an announcement. Ms. Collier, make sure you stay in touch with Mr. Kimler. You need to be back at your next court date for an announcement, and we'll see where we go at that point. All right.
You mind, since you vacated, I don't need a new motion to.
Okay, this is cause number 24 DCCR 0232. Mr. Nichols is here, Mr. Kimler, and sir, are you Raquel Glover? All right, so if y'all want to come up, let's before we go on, handle the motion to quash the indictment. So Mr. Glover is charged in 24 DCCR 0232 with unlawful possession of a firearm by felon. And the indictment alleges that he was previously convicted of endangering a child, July 13th of 2005, which was a state jail felony. And so Mr. Kindler has filed saying that some of the recent case law having to do with what underlying offense is charged would make this not an appropriate predicate for unlawful possession of a firearm by a felon. So specifically, the Hembry case was cited in the motion. I have also gone back. The Hembry case deals with the possession of a controlled substance. So obviously, it's not exact, but it does set out some of the parameters and the fact that there are cases that are not going to be considered if certain criteria met as unlawful or as predicates for someone not being able to possess a firearm. I also looked at US v. Williams. It's a 2024 case. It goes through a little more information on what the judge should do in order to determine, make the determination that we're talking about. And the determination, from what I can tell, really boils down to whether or not the defendant is a quote dangerous person, whether the underlying offense had some form of dangerousness. Obviously, some of those are easy if it's a murder or an ag robbery or an ag assault. Here we have an endangering a child. So the question, in my opinion, and I'll let you guys both argue, is whether or not that offense by itself would be considered dangerous and make the defendant a dangerous person. Also, before we go forward, is there any other criminal history that Mr. Glover has that's not listed in the indictment?
I would defer to the state.
There is a federal conviction for felon in possession of a firearm that is based on the same predicate under the same child endangerment. I know of no other felonies that he has. I know of no other felony convictions. There's a couple misdemeanors, but I don't think he has any other felony convictions.
Are any of those misdemeanors, what I can take into consideration under this case law, any criminal history, including misdemeanors or anything. And so I would like to know what those
I
are.
believe there's a unlawfully carrying a weapon that's from 1998 or 99, Your Honor.
Okay.
And I can look that up real quick if you need me to.
I do. That would be great because so that whatever finding I make, I can make sure and put whatever I need to on the record.
Okay. Yeah.
It's just, yeah, let me look that up real quick and then.
I'll file a motion for jury's elect punishment, by the way.
Okay, thank you.
There's a DPS report that you get for bond conditions. Is that something that would be relevant, Your Honor?
She wouldn't have it in this case. It's from 23.
Yeah. God bless you.
Your Honor, I'm showing unlawfully carrying a weapon convicted in 1999. I believe there's an evading on foot in the year 2000.
Is that a conviction?
It's a conviction.
So class B then, I believe.
Think so. He didn't, his sentence was 90 days. And that's a class B, so I don't think that would qualify.
Well, all of it can be taken into consideration is what the reason I'm asking. So even though it's not a felony, every bit of criminal history can be taken into consideration for me to consider dangerousness. Thank you.
And then a 2003 DWI conviction that is actually, I think, in conjunction with that endangering a child. And then as far as state history from 2003 up until this arrest, I don't see anything, Your Honor. The federal conviction, I believe, is in 2009. And again, I think that's the extent of his history.
I see an assault,
It did show up at the front.
Maybe I missed it.
from,
Shows summary in the summary.
it was dismissed.
Yeah, there it is, Judge. That's from 1997. It was dismissed.
See, and on the list that I get, it doesn't say what the disposition was.
Thank you.
No, I appreciate that. Okay, so we've got the endangering a child and an unlawful carrying a weapon and an evading, and then a DWI, and then a prior felon in possession of a firearm in the federal system.
Yes, Your Honor.
So the way I read this, really is that the burden is on the defense to prove that he's not dangerous, or that these are not dangerous offenses that would, do that. So, Mr. Kimler,
All right, briefly, having sworn, answer a few questions.
would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole, or in this trial, if we go to trial, will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
You state your full name.
That's you.
Mr. Glover, you understand you have a prior conviction for endangering a child, is that right?
I do.
What were the circumstances of that case? What happened, the factual circumstances?
I was drinking that night. My girlfriend at the time had a daughter on her lap. I was pulled over. I was put out of the police department.
Okay, so was this a DWI with a child in the
Yeah, I
car?
believe so.
There was no wreck, there was no high speed, except
Just
nothing.
traffic stop.
So the endangerment was the fact that you're operating a motor vehicle while intoxicated, is that
Yeah.
right? As far as your dangerousness now and your criminal history, are you employed? What do you do?
I'm employed. Gabriel Funeral Home.
Sorry.
He's employed with Gabriel Funeral Home. What do you do in that capacity?
Funeral home assistant.
And you have responsibility for what? What do you do at the funeral home?
Well, I transport, dress casket, I prep funeral service, transport, first calls.
And you pick up bodies, is that right?
I do that.
You do that from crime scenes?
No, the county medical examiner.
Okay, from the medical examiner. You don't go to crime scenes?
No.
It's a responsible position, right? You work,
Yeah.
haven't had any problems with that? When's the last time you were in trouble? Like, other than this case,
2023,
this case, right?
over 20 years ago.
Right, okay. Pass witness.
I am trying now, unless you guys have it handy, to see if there's a way for the clerk to go back and find the probable cause affidavit from that underlying.
And Your Honor, I've looked at it and I'll pull it up for report, but I'll tell you that he's accurate as to what it alleges.
Well, the indictment alleges excessive speed and some other things, so
I think
know-
it was, I'll pull it up for the
Okay.
court, but I remember it, essentially someone called in a reckless driver, swerving speed.
Just, you've had your opportunity. Let us look up what I need to look up. You'll have an opportunity through your attorney in a minute.
I'm sorry about the late date for filing this motion, Your Honor. I was doing the research over the weekend and kind of came across this case.
It's all right.
Thought I needed to do.
Yeah, it's definitely
do
something that we all need to be probably more aware of. Yeah, I know the Hambre case is on, they've at least filed a petition for
Okay.
review, but I haven't, it did not show if it had been granted
For
for
en banc?
discretionary,
En banc or for PD or for?
PD for cert, it looked like,
Okay.
from what I could tell, but I may be wrong, but something is still out there
Out there.
potentially on it.
Judge, here's the probable cause affidavit.
Thanks.
Endangering child case.
You don't have any objection to me
No,
reading
ma'am,
this?
no, don't you?
You want to take a look at it?
All
It-
right. Sorry.
Yeah, and it doesn't, I don't know, the indictment alleges excessive speed, but what this really comes down to is, looks like there was an EMS unit that was behind Mr. Glover, and they're the ones who called it in. And stated, sir, just stop. I already told you to stop until you were asked a question. Let us keep our train of thought and figure this out. And if we need to hear from you, then Mr. Kimler will ask you at the certain time the right question. Please don't make me ask you again, okay? So this is just what the probable cause says. It says that the Gold Star EMS unit was behind a 78 Chevy, struck a curb several times, failed to maintain a single lane. Dispatcher advised that EMS unit felt that the vehicle was going to wreck if it was not stopped. They stopped the vehicle, the officer stopped the vehicle 3600 block of Highway 69. Driver, Mr. Glover, they could smell a strong smell of alcoholic beverage, had slurred speech and could not say his ABCs nor do a finger count test, conducted standard field sobriety test, failed all tests. The vehicle that Glover was driving was occupied by a front seat passenger who was carrying an 8-month-old baby girl in her lap. And he was placed under arrest, refused to provide a specimen, and then charged with this. That's,
And then we have the conviction for the underlying BW as well. I think is what
I believe so, yes. So there was a conviction for the endangering a child as well as the underlying DWI. So I guess, let me ask, Mr. Nichols, what's the state's position?
Just so that we're upfront honest, Judge, my read of what the court said in Hembry was that it is the government's burden to prove the history and tradition. Well, it's actually a different issue than the dangerousness part.
Right.
But as far as dangerousness, we look at what his criminal history is. None of those stick out as what are typically considered aggravated or violent offenses. There is a weapons possession conviction for a misdemeanor prior to this. I think there's a element of danger in reckless driving while under the influence, however, especially with the child unsecured in the front seat. I do think that is dangerous. There is certainly some time since that's occurred that would tend to mitigate that dangerousness. And I won't pretend that this is these are fresh cases, but that is his history and that's what he has done and been convicted of.
Mr. Himmler?
No, I suppose if the question is obviously endangering a child, the statute itself that he was convicted of said it's danger. So that's one thing. But if you look at the underlying circumstances of that, I think that was filed at a time when we didn't have the DWI child passenger statute. I may be wrong about that. But it probably, if now, that probably would have indicted the DWI child passenger, not the endangering of the child. But I don't know. As far as the dangerousness is, if it's an analysis of what he is at present, I think that he's demonstrated he's gainfully employed at Gabriel Funeral Home. Bears like a certain
Yeah, well, I guess, so I don't want to, let me stop you because the dangerousness that I can tell are the dangerous people under that Williams case. It has really not to do with anything other than their criminal history. So it's not what they're doing now, what they were doing then, good person, bad person, how long it's been. It's what those offenses were and whether or not he would be considered then a dangerous person because of that criminal history.
Basing the inference on the criminal history alone, but not present circumstances.
That's the way I read it.
Okay.
Yeah. And it goes on to say, and this is a 2024 Sixth Circuit case, this Williams case. It just goes into this one was the underlying criminal history was, I think, much different. We didn't have the issue of the possession of a controlled substance. And it just goes into a little more detail of what to look for than the Hembry case does. The Hembry case really was very specific about drugs and those types of cases, and that a possession is one thing, a possession with intent to distribute could be considered dangerous, whereas a plain possession wouldn't. And that's kind of where it is.
I'll leave it in a school zone, perhaps too. That might
Right. But none of those apply. So, I mean, and here's the thing, I want to do the right thing under the law. I don't
Judge,
disagree, I guess, with really both of you that this isn't an egregious underlying offense. But I also, it is literally in the indictment, uses the word danger, that he intentionally, knowingly, recklessly engaged in conduct that placed the child under 15 in imminent danger of death or bodily injury by operating. So I do think, just by the nature of that itself would be that. I don't, but Mr. Nichols, you had something else. I'm sorry.
I was just going to let the I don't have that Williams case in front of me. It's not what I'd looked at. I focused more on Hembry, and I think it was Diaz was a similar case or one they cited too. and Hembry gets into this historical analog of,
The analog, right?
and that puts the basis or the burden on the government to show this analog. And frankly, I don't know that I've had time this morning to develop the facts necessary to do that.
Well, then potentially instead of granting or denying the motion, maybe we reset it for a week just for this hearing. Any information that you have and want to present with regard to that, we can do, and that way and then I'll make a ruling, and either it's back on the trial docket quickly or I grant it and it's gone.
We could just reset it for a trial docket, make the ruling and pick a jury. If that's, I mean, I'm not asking to delay if the court wants to try to get it tried. I mean, we can reset it for today is what I'm saying. I don't know that we'd have to reset it once you make your ruling for another trial docket, just set it on the next trial docket maybe, or.
Well, we need to have a hearing. So I have to reset it to a hearing date. I'm not gonna, I want everybody to know. I mean, obviously, especially, I would think Mr. Glover, if I'm going to,
Can I have 1 second?
yeah, if I'm gonna grant your motion, then obviously he wants to know that sooner than 3 months from now. So if I'm not, then we need to get it on the trial docket.
She wants to make the right decision.
Thoughts?
I feel like we'd probably end up arguing it again at a later date if we move forward right now.
That would
makes
probably
sense.
what? No.
I don't, my understanding of what's required by the government in this historical analogy is it's going to require a little bit more from me than what I have this morning.
Right.
So I want to get it right. I want us to get it right the first time.
I agree. All right, so let's do this. I'm going to, and it's not something, once you have that done, we can just maybe set it on a regular docket at 11 or something in a couple of weeks. And
that should be plenty of time, Judge. I think I could do it before the end of this week. I just need more than half a morning.
sure. Okay, well, then what I'll do in just a second is I'll go out and let the jury know. Mr. Eckhart is in jury. Mr. Coleman, they had a jury seated this morning over in Orange, so he is actually in trial. So that case is not going to be